Hi, this is Nine Gonzalez, and welcome to another episode of Making Sense. Well, today we're going to discuss a really important topic, which is wills and what happens when you do a will and why you need a will, and what happens after you pass away. And, the only two things that are certain are death and taxes. And a lot of people are unaware of what is it that they need to do and the importance of having a will. So I have an attorney that is joining me as a guest, and we have Darren Powell. And Darren, I want to thank you for coming here and discussing this important topic with us.
Well, I appreciate that. What you're talking about is probate, and I love that word.
Okay.
And it's a word that nobody knows what it means. It's scary. We don't have television shows about probate attorneys. We do about criminal defense.
Right.
So I like that word probate. So.
Okay. Well, we'll get a little bit into that, but tell me a little bit about yourself and about your practice, and a little bit about what is the type of work that you do.
Well, right now, primarily what I do is probate, and I lean heavily towards probate litigation. When I say probate, what I mean is going to court with documents to clear up a person's estate or to do a guardianship. And by litigation, I mean sometimes we fight about these things. And that's the area of the law that I like, is actually fighting about it. A lot of times there's no contest, everybody agrees it needs to be done. So whenever I say probate, that's what I mean, straight up probate. When I say fighting, I mean probate litigation. So,
okay.
You ready to talk about probate?
Well, let's talk a little bit about a will. What is a will, and does everybody need a will?
Well, a will is a document that's prescribed by the estate code to have certain formalities, and it is a statement by somebody which is examined after their death to determine what property goes where.
Okay.
Because ultimately what a will does is it distributes your property after death. Well, there's a lot of requirements, and those requirements have to be met. For example, you have to have 2 subscribing witnesses. And if you meet those requirements, we have what you call a statutory will. And a statutory will is really the best way to do it. You go in, you get a self-proving affidavit, which means the witnesses, the testator, swore in front of a notary that they did this with all the ceremony required, and a notary signs the affidavit after the testator signed the will. Then we have a document that we can take to the court after death.
Okay. And does everybody need a will?
I would say everybody who has property that needs to be distributed after death needs to have a will. And if a client comes to my office, that's one of the questions I'm going to ask them. Do you really need to do a probate? Let's be honest, attorneys are expensive.
Right.
We're worried about the cost of what a probate might be. And so that's one of my first questions. What did mom or dad or whoever the decedent is, what did they own? Because sometimes we don't need to go to probate. Let's say, for instance, you have nothing but life insurance.
Right.
Chances are you did a beneficiary designation with your insurance company which stated who's going to get that money.
Sure. That's what we call pass-through money.
That's right. Well, we call that a non-probate asset in probate. So if, for instance, you didn't say who's going to get that money, it's going to go to your estate. So now we have to do a probate because we're going to have that money come in and be administered by an administrator.
Right.
If you did a will, you named somebody to do that, and we call them an executor. So the executor will distribute the money the way you want it to be distributed.
So the executor is the one that handles those affairs once you pass away?
If you named them in a will.
Right.
If you didn't name them in the will, the court's going to appoint somebody, and that's called an administrator.
Okay.
Yeah.
And, I've heard of all these websites that you can go, or you can just buy a document and do a will yourself.
Right.
Or
go to JAG.
Is that okay or
not?
I
love it. I love it. That's guaranteed business for me. Most of the time, those don't actually meet the statutory requirements. Right. Or when people do it themselves without any assistance, they fail to satisfy the requirements. So that means that you're probably going to fail when it comes to that document. I'm not going to say all the time, because sometimes they're done right. But there's a lot of mischief and a lot of room for error when you try to do things yourself in probate.
Okay, so we got to make sure that every I is dotted and every T is crossed, and make sure that all the requirements are met, because essentially that will could be voided, right?
It can be, but most likely it's not that it's voided, it's that it's not valid. It doesn't satisfy the requirements. The witnesses have to sign in front of the testator. The testator has to sign in front of the witnesses. It has to be done all together as a group. The words in the will have to actually do what you want them to do. I've seen a lot of wills. Sometimes people come in and they're not satisfied. They'll show me the will, and I'll ask them, well, what do you think this will says? And what they say is different from what I'm reading in the will. So you need to make sure it does what you want it to do.
And then also, once you have a will, it needs to be updated every now and then if there's changes, correct?
Yes, but I would say substantive changes. For instance, if you get a divorce, you're not going to want to leave everything to your wife. In fact, the family code says that will's now void for that situation. So you're going to want to redo your will. If you lose a child, if you lose a spouse and they're the ones that are going to receive everything, if they're named as the executor and you didn't name anybody else, there's a lot of reasons to re-examine a will after you've had a big event in life.
Okay. And what happens if you don't have a will and you pass away and you do have some property? I've seen some instances with some family members that they die without a will, and then, you know, everybody in their lineage is responsible for property, especially it happens with property and nobody takes care of the property taxes, and then they're stuck with it and nobody wants to deal with it, and there might be 6, 8 people involved and nobody agrees. What happens?
It's not unusual in El Paso for people to not do a will. Nobody wants to think seriously about the single fact we know in life, and that's that you're going to pass away.
Right.
And so it's not unusual, and we call that intestacy. You've died without a will. And what's going to happen is the state of Texas has prepared a will for you, and you might not like it. And probably the worst thing that can happen is, let's say mom and dad have 12 kids. Dad had 1 child before he met mom. He dies without a will. His share of the community estate goes to the children, not to mom. If he and mom only had children and he had no children outside of his relationship with mom, then mom gets everything from the community that he owned with her. So that, you know, Texas has already written your will. So if you want to do anything different than what the state of Texas wants, you better get out there and write it yourself, because in El Paso, as in other places, people's circumstances are not necessarily what the legislature in Austin thought they were going to be. And so, you know, we have to think these things through ourselves and make sure that we're doing what we want to do.
And as we know, some people's family tree can be very, very complicated.
Very complicated. A lot of times mom dies or mom and dad divorce, and then dad remarries, has second wife, maybe she's younger. The kids are guaranteed to hate her. That's a moneymaker for me. So what usually needs to be done is there needs to be a discussion about, you know, what are the kids' expectations? What is the new wife's expectations? You know, what are the assets that your estate's going to have? How are we going to divide things up? It's good to have that discussion before it happens.
And these are, you know, real life issues that I like to bring up to my students, because they never think about this, especially when, you know, they get into a serious relationship or they're getting married. And a lot of people don't know, and that's why I wanted to bring you in and discuss these things.
Well, you know, if you have nothing, you probably will not do a probate. For instance, when my dad passed away, he didn't own anything. And there was no reason to do a probate.
And
no assets, no probate.
And somebody asked me, does, you know, after you pass away, then you take that will to court and to probate? Is that what you're talking about?
Right. Well, actually, you have a 4-year statute of limitations on probating the will after date of death.
So will does have an expiration date?
It has an expiration date on it.
Wow.
Exactly right.
So what happens in probate?
Well, let me just finish that thought. If you wait the 5th year and try to probate that will, then the judge is going to say that will's not valid anymore because you waited beyond the statute of limitations on that will. So now you have to do an intestacy. And when I say that, I mean you have to do a determination of heirship, which takes twice as much time. Let's talk about what happens in court. If you have a will and you come to me, I'm going to file an application and I'm going to take that will to the court. The court will examine it. We'll have a hearing. You'll be appointed the executor. We're going to do an inventory, and then we're done with the court. We divide the property, we sign the deeds, we do what needs to be done. Relatively quick and easy.
Okay.
If you don't have a will, then I'm going to have to file an application to determine heirship and file an application for an administration. We're going to have independent witnesses come to court and testify to the court about who the kids were of whoever the decedent is. That's going to take time. And we have to appoint an attorney ad litem, which means the court will appoint a separate attorney that doesn't know us, who's going to go out and interview those people and determine that there's no children outside the marriage.
Wow.
And I'll be honest with you, people don't really like to hear that, but that's what happens.
Right.
I've been to court more than once, and just as we're getting up to talk to the judge, my client leans over and says, oh, by the way, there were some other children, they live in Juarez. And I'm like, well, thank you very much. Judge, can we have a continuance and come back on another day?
And all of this sounds like really expensive. You know, the more time you spend.
Anytime you're talking to an attorney, you're being charged.
Okay.
And so the expense of doing a probate is related to the amount of time it takes an attorney to do what needs to be done.
So it's better to be prepared.
The least expensive experience will be probating a will. If you have no will, it's going to probably cost about double. And we haven't even talked about guardianships yet.
Okay, and I've seen, you know, in some of my relatives' cases that, you know, they passed away without a will, they leave this property, nobody wants to take over it, they owe back property taxes, and then all of a sudden the property is being foreclosed. And
well, the state, the county, the city, they have hired attorneys to collect taxes owed to them. And they're aggressive about it.
Right.
So if mom and dad both die and your cousin's living in the house not paying taxes, there'll come a point where they're going to notify you all that they've gone to court to foreclose on the property to pay the taxes. And so you'll all be notified. It's best to have done that ahead of time, done the heirship. If the house is worth, you know, $50,000 and mom and dad had 10 kids, we're not looking at a lot of recovery. And after you pay the $25,000 in taxes, there's not much there.
Probably not even worth it.
Yeah, it may not be worth it.
Right. And then sometimes that lineage, some of them have passed away.
And their kids stand in their place.
Right.
Exactly. So we're looking at 28 people suddenly.
Right.
What a mess.
I know. It's and I ran into that situation with a family member, two family members, and we were talking about this, and it had all been avoided if they would have done a will. You know, that would have been done, and they would have been prepared. But like you said, a lot of us don't want to talk about it because say, let's go get your will down.
Yeah.
Are you already putting me, 6 feet under? That's the assumption. But
well, you know, dying's not the worst thing that can happen to you.
But the best thing is to be prepared. Well, we'll continue on with this fascinating topic and inform the public more about what is it that they need to have ready and their affairs in order before they pass away. So it makes it easier for the family. And we'll talk about that on the second half of Making Sense. Thank you. Welcome to the second half of Making Sense, and we were talking about wills and probate and have your affairs ready before you pass away so it makes it easier on your family. So let's talk a little bit more about what this whole package involves. Do I just need a will or do I need other things?
You know, if you come into my office and we start talking, that probably the last thing I'm worried about is doing your will. because I'm not kidding when I say there's worse things that can happen than death.
Right.
As people live longer, their health gets worse, their mental capacity gets worse, or maybe you have a motorcycle, fall off it, hit your head. There's a lot of situations where people are incapacitated.
Right.
And probate is not just about wills or intestacy, it's also about guardianships and taking care of people who can't take care of themselves. Some guardianships are entered into willingly and some are not so willingly entered into. Let's say, for instance, dad's passed and mom now has Alzheimer's, which is just one type of many dementias. It's too late for us to do some of our estate planning. If we had backed it up and when mom and dad were 10 years younger, everything's fine, they came to see me, I would have done some other documents for them. And probably one of the most important documents that we need to think about is designation of a guardian in case the need arises.
Okay.
And sometimes the need does arise. I've had young people do these documents and literally fall off their motorcycles, and they're going to need a guardian because they're no longer able to take care of themselves, groom themselves, feed themselves, clothe themselves, pay their bills, file suit against anybody. And so it's a good idea to have that document, designation of a guardian. In Texas, there's two kinds of guardians. There's guardian of the person. That's somebody who will make sure you go see the doctor, get groomed, get fed, take your medicine. Then there's guardian of the estate. That's somebody who's going to take care of financial matters for you. If you have money and you are incapacitated, you're going to probably need a guardian of the estate. So I usually name both in that document. Another document you might need is a medical power of attorney. As mom ages or anybody, they might not be able to explain to the doctor that they want to consent to the treatment he's recommending. Right. And so somebody has to be named while the person has capacity. So we need to do all this ahead of time.
So those guardianships, sometimes they're called power of attorneys, like a No, it's different.
Exactly different. Okay. Yeah. And let me sort of separate it for you. A power of attorney is a person who's your agent, and they can continue to act even though you've lost capacity, and they will handle your matters for you.
Okay.
A guardian is somebody who the court's going to appoint and supervise, and they will do those things for you.
So is it better to have a guardianship than a power of attorney?
It's better to have both. And the reason is we enter these things slowly, like walking on a long beach and you're ankle deep, then knee deep, then waist deep. I'm not going to assume that you instantly have an incapacity. I'm going to think you walk into it slowly and we don't notice it at first. You need a little bit of help, so we'll do the powers of attorney. We have a statutory durable power of attorney to help to have an agent to do your financial things for you. We have a medical power of attorney for medical decisions. Those people are your agents. They'll work for you. You can say, no, I don't want to do that. I want to do this, and then that will happen. You're still in control. Then the doctor says, well, you lack capacity. You can continue to have an agent act for you even after you don't have capacity. But eventually you get into some kind of a crisis and the hospital says, no, we need a guardian now.
Right.
Or
that's where the other document kicks in.
That's where you have to go in and get court supervision.
Right.
And that's where the other document kicks in.
Because if not, then the state can appoint a guardian.
Can and generally will. The state of Texas, APS might investigate, find that this person's being neglected, file an application for a guardian, then suddenly they're taking over. Wouldn't it be nice if mom had already done a designation ahead of time?
And APS is Adult Protection Services?
Adult Protective Services.
And does this include do not resuscitate orders? Or can it?
Do not resuscitate is generally a document you do in the hospital.
Right.
And you're doing that basically to say, I don't want anything to revive me if I have a medical crisis.
But you don't have the capacity to fill that out while you're in the
hospital.
Well,
what you do ahead of time is you do a physician's directive, and sometimes people call them living wills. But I would rather call it a directive to physicians and family stating how you want your end of life to occur. Mm-hmm. And so you want to say that in these terminal situations where no treatment is going to make me better, I personally would select being comfortable, being medicated, And if we've lost the capacity to think, sometimes you're in a vegetative state, sometimes you have to withdraw food and water.
Right.
Because the person's not going to survive. One of the biggest cases on the matter was Terry Schiavo.
Right.
And that's a decision you should make well in advance of any of this stuff needing to be done. You don't want your family trying to second guess you. You want to tell them what your preferences are.
Wow.
So that's a physician's directive. So we've talked about two kinds of powers of attorney. We've talked about designated guardian. We've talked about physician's directive. Another document I like to fill out is agent to dispose of remains. And that's a document saying how you want to be disposed of.
Right.
I mean, where do you want to be put?
Whether you want to be buried, you want to be cremated.
And who should be in charge?
Right.
Well, let me give you an example, because actually I've made money on these situations. Mom passes away. Dad has a live-in girlfriend. Texas has common law marriage.
Right.
And she might decide that she's going to bury Dad in Abilene. And the kids are all in El Paso. There's going to be a fight. So Dad, ahead of time, needs to do a document that says who's going to be in charge.
Wow.
He needs to think about the end.
And it's sad to see that, especially during death or major illness, people start fighting. Family members start fighting, and sometimes the true colors come out, and all these people come out of the woodwork, and that's why I think we need to be prepared.
Well, I think you're right, but I have to tell you, I live on the dark side of life, and so if everything goes pretty smoothly, there's not a lot of work for me to do.
So if you take the will to probate, and so can it be contested there?
Yes, a lot of times people do want to fight about the will, and sometimes Mom did more than one will, and people don't know that there's a more recent will.
Right.
That's not really a contest. That's more of a, oh, I didn't know. Other times they want to say, oh, well, my sister was living there and had complete control over Mom and made Mom sign a will leaving everything to her. Well, that's probably going to lead to a will contest, because that sister's going to tell me, well, I was the only one taking care of Mom. Mom and I had a really close relationship. Mom wanted to make sure that I got taken care of because I just spent 10 years of my life taking care of her. So those are the kinds of situations where we have will contests, and that's not uncommon.
Right. And so I've heard, do a will, get all these guardianships and power of attorneys ready, and medical directives, but I've also heard of trust.
Well, that's true. And a trust is a document that you've done generally during your lifetime that is going to manage your property for you through a trustee, which may be you or somebody else. And a lot of times people want to put everything into a trust because they want to avoid probate. Quite often you're going to end up in probate anyway, even though there's a trust.
Really?
Yeah.
Wow.
So,
because that was one of the biggest selling points.
Yes,
Make a trust so you can avoid probate.
Yes. And the best part is the trust is sometimes more expensive than just doing the will.
Right.
And so you need to really look at your assets and speak to your attorney and think long and hard about the positive and negative that go with each. For me, what I look at is what's the likelihood of litigation. If there's going to be litigation, I probably lean more towards the trust. What's the probability of everybody getting along? I'm probably going to do the will.
Right.
So we need to look at those things kind of carefully and decide. Let's say that you're an older gentleman and you don't really want to manage your money, and so you've done powers of attorney and you've put everything into a trust. You would hope that everything would go smoothly after that. Well, let's say there's no kids, let's say there's just nephews and nieces. Things are not going to go smoothly, because I find nephews and nieces to be the most litigious when it comes to estates if the decedent didn't have children of their own.
Right.
Probably the second most litigious situation is where there's children of mixed marriage. In other words, there's children from first wife, children from second wife, children from third wife, and they all have different expectations.
Right, and there could be a lot of anger issues, a lot of revengeful
Yeah, Mom
issues.
loved you best, Dad loved you best, I didn't get what I deserved, money equals love.
Right.
So that's one of those situations that you need to look at. I really think you need to spend time speaking to your attorney and finding out what the costs are and what the benefits are and what's going to work best in your circumstances.
And what if you have children and let's say mom and dad are both in an accident and they pass away? Do you need to state who's going to take care of those children?
Typically in a will, in that circumstance, we would name a guardian for the minor children. But you don't need a will for that. The legislature's provided a statutory forum where you can name a guardian of your minor children in case that happens.
Okay.
The parents are each natural guardians. So let's say mom and dad aren't married and something happens to mom. Dad's the natural guardian.
Right.
So he's going to have custody. But she might want to name her sister too, so that her sister would have standing to look into the matter.
Right.
To make sure that everything's
But sometimes
okay.
aren't those guardian issues sometimes challenged because they think they're not suitable or things like that?
Yeah,
or
exactly.
Grandma wants to raise.
Suitability, that's the word.
Right.
Yes, exactly. A lot of times the contests and guardianships are between different groups who want to have control, generally of the money, but also of the person. And they're going to argue about who's the most suitable guardian. And yeah, that's very commonly litigated in probate court.
Okay. So, some of the questions I get, and I guess it all depends, on the attorney, but on the average, a whole package. Let's say I go to you and we want to get the will and all these guardianships and directives put together. About how much will the cost be, more or less, on the average?
Well, that's kind of a tough question.
Right.
Okay, and let me just say, I'm going to throw some numbers out there, but I'm not advertising.
Right.
Okay, because that would bring in ethical
Right.
problems. I would just suggest that that you need the whole package. A will's not enough. You really do need it all. And then I would suggest that it takes a certain amount of time for an attorney to talk to you, draft up what you need, have you come to the office, have his staff tied up with 2 witnesses and a notary,
Right.
and then send you off with all your documents signed. And that's probably, what do you think, 2 or 3 hours? That would be what I would expect.
Okay.
And most attorneys, I would think, charge more than $200 an hour.
Okay.
Many attorneys, especially big law firm attorneys, probably charge in the 300s.
Right.
So I can't.
That gives you sort of an idea.
That gives you an idea of what you should or shouldn't be paying.
And if you're married, both of you have to do a will.
That's right.
You and the spouse, correct?
That's right, exactly. Yeah. We don't know who's going to die first, but we do know everybody's going to die. And I would also suggest that you find an attorney who actually, attorneys kind of specialize a little bit in what they do. Criminal defense attorneys, immigration attorneys, bankruptcy attorneys. Sure. You should find somebody who actually practices in probate and has some experience dealing with the things that are going to be in your will.
Right.
So I would look for somebody like that, and I would expect to pay a couple $100 an hour, and I would expect to take a few hours to actually do the work.
And it's important to do this while, you brought one of the suitability issues or something that can be contested is mental capacity. You got to do it when you have a sound mind, correct?
Exactly.
You can't wait.
Well,
because that can be challenged.
It will be challenged. I actually know a lot of psychiatrists, and it's because those are the expert witnesses that we bring to court to talk about your capacity. Wow. Those are the people that are going to sign the documents that say, this is my prognosis. They don't have capacity, and they're not going to have capacity, and this is the degenerative disease that's causing that.
Well, thank you. I hope this is valuable information for our viewing public, and I hope everybody gets what they need to get ready before anything happens. Thank you for taking time out of your busy day, and maybe we'll have you again on another show and talk about different topics. And thank you for tuning in for another episode of Making Sense, and we'll see you next time.